Okay. Hello, Stephanie. It is almost 6. We're so glad to have everybody signing in. Okay, well, I see it's 6 o'clock, so we'll go ahead and get started. Good evening, everyone. My name is Tracy Irby, and I'm the director at TWU Center for Women Entrepreneurs. We're happy all of you are here tonight, and we see some new faces as well. The Center for Women Entrepreneurs was funded by the state legislature in 2015 just to help women entrepreneurs anywhere in the state of Texas. And they thought, what better place to put it than at Texas Women's University? So we help women through small business advising, funding, networking and training events like this, and research into women's issues in the workplace, women in business, and there's been some recent diversity and inclusion as well. We're so happy, again, you're here. Our center is part of the Jane Nelson Institute for Women's Leadership. There is also the Center for Women. I always get those mixed up, the women in politics and public policy, and our Center for Student Leadership. The Institute is dedicated to preparing women to take on successful roles in business and public service, to have the education to establish careers as C-suite executives, and to learn the skills for building entrepreneurial businesses and the framework needed to run for public office. We have Donalisa Stinyard here, our program director, and Samantha's here as well, and she's going to be monitoring Facebook for anyone that may have questions there. Donalisa is going to be working the slides tonight, so if you have any questions for your speakers, you can send them to me, Tracy Irby, in chat, and I'll also be monitoring the chat box. So let's go ahead and get started. I'm so excited to introduce our guest tonight. We have Hope Shimabuku. She is the regional director. She carries out the strategic direction of the Undersecretary of Commerce for Intellectual Property and director of the U.S. Patent and Trademark Office and the Texas Regional Office, focusing on the region and actively engaging with the community. Ms. Shimabuku ensures the USPTO's initiatives and programs are tailored to the region's unique ecosystem of industries and stakeholders. We also have Paola Agudalu, the outreach coordinator. She received her BS in civil engineering from the City College of New York and worked as a structural engineer for a consulting engineering firm in New York City. She moved to Alexandria, Virginia to join the USPTO in 2011 as a patent examiner in Art Unit 3633. She became a primary examiner in 2017 and moved to Austin, Texas that same year. So ladies, welcome. We're so excited to have you here tonight and learn about patents and trademarks and everything that you do.
Thank you so much.
Thank you so much, Tracy.
Thank you, Tracy. I'm going to speak first. So again, my name is Paola Agudelo, and Tracy, that was a fantastic pronunciation of my name. Thank you for that. I'm really excited to be here sharing my experience and my tiny little bit of knowledge with you all. Before I start talking about patents and intellectual property, I would like to give you a brief overview of the PTO in general. So if we could move to the next slide, please. Um, in the fiscal year 2020, there were almost 13,000 employees in the patent office. And as you can see here, most of them are patent examiners like myself. And there's also a team of examining attorneys in trademarks. And we have the trial and appeal boards for patents and for trademarks. So we also have judges working on those boards. In terms of patents, there were more than 650,000 applications filed, and we had almost 400,000 patents issued. And similarly in trademarks, we were very active in the fiscal year 2020. A fun fact about actually this year, last month we issued the patent number 11 million. So within the history of the patent office, there have been more than 11 million patents issued. Just curiosity. And below here in this slide, you can see a picture of the headquarters of the PTO in Alexandria, Virginia. And so I'm encouraging anyone who stops by Alexandria to come and visit us. It's a beautiful campus. We have an Inventors museum, which is really interesting. Can we move on to the next slide, please? So in the year 2011, President Obama signed the America Invents Act law, which is also known as the AIA. And one of the provisions of this law was it allowed the PTO to establish satellite offices. So the first satellite office was opened in Detroit, and it's actually known as the Midwest Region Office. So as you can see in the map, each satellite office serves a certain number of states. And for instance, the Texas Regional Office, which is indicated here in blue, it happens to have the name of the state, but it actually serves the states of the South from New Mexico all the way to Tennessee and Alabama. Next slide, please. So speaking of the Texas Regional Office, our office is located in Dallas. It's that beautiful building pictured in the slides. And during normal circumstances, the office is open to the public. There's a public meeting space. There we have a hearing room. There is an examiner interview room where the examiners meet with attorneys when they want to. And there is also a public search facility. I will get into what the public search facility is in a little bit. But in the meantime, I just wanted to let you know that one of the goals of the regional office is to conduct outreach. And one of the ways in we do this is through connecting one-on-one with stakeholders or potential stakeholders like you. We'd like to let you know that Director Shimabuku and I are available to connect with you, to have a quick conversation, to listen to any feedback you can provide or address any issues you may have, or even if you have like specific questions regarding your business or your product, we're here for you. So I'm going to be providing my email address here in the chat. And so please reach out if you're interested in scheduling a one-on-one with us, or you can also please let Dr. Steiner know that we are interested, that you're interested, so that I can contact you directly and set up a meeting with you. And now, if we can move on to the next slide. No one more perfect to talk about intellectual property than the one and only Hope Shimabuku. So I'm gonna pass it on to Hope, and she's gonna tell you about intellectual property.
All right. Thank you, Paola, and thank you for that very nice introduction to both Tracy as well as Paola. Can we move to the next slide, please? What I'm going to do is, and then the next slide after that, please. What I'm going to do is I'm going to talk a little bit about what is intellectual property and how that fits into your entire portfolio. When you're thinking about intellectual property, you need to think of it as any other asset that you might have. And so when you're thinking about intellectual property and your business strategy, intellectual property should be a part of that strategy as you are looking at your entire business. Why do you want to do that? And there's a couple of reasons. One is if you look at the words themselves on intellectual property. So what is intellectual property? Intellectual property is something that you have come up with, you have thought about, you've come up with, you've brought it up as an idea in your mind, and it is like property. It is something that you can own. It is something that you can transfer title to your kids or to your heirs or to share with other people. You can also license it or rent it out, for example. If you own it, like a house, you can rent it out and let people borrow your property and your different ideas that you have come up with, similar to like a car as well. You can lease it. And so when you're thinking about intellectual property, the things that you have developed and you have come up with, that is an asset, and it is something that you can treat like any other real property or physical property that you might own. So let me go into the next slide and talk about what are the different buckets of intellectual property. When we talk about intellectual property, there are 4 different types of things that we're talking about. If we can hit return. So the first thing that we think about is a patent. And so this is something that my office actually evaluates and examines and grants at the end of the day. A patent is anything that is an invention. It's a widget, it's a gadget, it's a process, it's a new material that you have developed, a new chemical formula. All of those things, they are inventions that you have come up with and you have developed. And the intellectual property right, when you apply for it in our office, is a patent. If you can hit return again. And so the other bucket of intellectual property is what my office also does, and that is a trademark. A trademark is a source identifier. And a source identifier is who is providing that particular good or service when you look at that name or that symbol. So the example that you see right here is Gmail. You know that the provider of Gmail is Google. Now, specifically, you know that because it's provided by Google, and you know that Google, when you look at the word Gmail, you know that it is an email service that they are providing, and they are the source and the creator of that particular email service. If you can hit return one more time. The next bucket of intellectual property is copyright. Now, copyright is not something that is granted by my office. The U.S. Copyright Office is the entity that will actually register your copyright. A copyright is anything that is artistic or creative that is embodied in a tangible medium. And a tangible medium is anything that, that you put that artistic work on. So, for example, it could be in a book on a piece of paper. It could be saved on your hard drive. So software is also considered copyrighted. It could be something that you have created with sculptures, right? You have imprinted it into a rock or clay or something else. And so that is something that you can think of with copyright. The last bucket is trade secrets. Now, I know that I'm going through these really fast, but we're going to go into much more detail in each one of them later on in this presentation. The last bucket is a trade secret, and a trade secret is a secret that has some sort of commercial value by keeping it secret and not being known by someone else. One trade secret is the KFC recipe. The recipe on their fried chicken, that skin and that secret recipe is a trade secret. And so there is value in people not knowing what that secret is. And so again, we'll go through each of these in more detail as we're going through this presentation. Next slide, please. So let's look at an example of intellectual property and how it all comes together. Intellectual property usually comes together, there are many different types of intellectual property in one single device. So just because you have invented or you've come up with one certain thing, it doesn't necessarily mean that it is mutually exclusive. As a matter of fact, most of the time it exists together in one product. And looking at this particular cell phone, that is something that you can actually see that in. So this particular cell phone actually is a Samsung Galaxy Note. Okay, the Galaxy Note is a product that is made by Samsung, and so it is a source identifier. So with Samsung, Samsung is the name of the company, so it's a source identifier. You know who made this product. Within that actual product are patents. And so what kind of patents are there? There are patents that are related to the camera, to the battery, to the screen itself, to the antennas within that, to the software, which is the data processing methods that are included in there, and even the circuits that are associated with that. Some people say that there are approximately 250,000 patents that are embodied in a single cell phone. Can you believe that? Lots and lots of technology in there. There are also design patents, which is the ornamental design of a patent, and that's embodied in there. There's copyright because software code is considered artistic, and it's embodied and saved in a memory device, right? And then there's probably trade secrets in there. We don't know what they are, so because they're a secret, right? But Samsung probably has some trade secrets that they have kept in here, and we don't know what they are, but they are valuable, and Samsung may not want anyone else to know about it, right? So now I'm going to turn it back over to Paola, who's going to go into more detail about patents. So if we can flip to the next slide, please.
Thank you, Hope. Okay, so patents. Can we move on to the next slide, please? So what is a patent? A patent is the grant of a property right given to an inventor. Who gives the right to an inventor? The government, and in this case, specifically the Uspto, which is a government agency. So the patent is the right to exclude others from making, using, or selling the invention. It is important to note that getting a patent doesn't give you the right to make and use and sell. It's actually the right to prevent others from doing that. Next slide, please. There are three types of patents. We have utility patents, which I would say is the most common type of patent, which is it could be to protect either a process, a machine, or a device, or a composition of matter. We have also design patents. Design patents are for protecting the external appearance of a device or an object. For instance, like Hope was showing with the phone example, the shape, just the little shape, the specific shape of the home button, that's a design patent. And we also have plant patents. Plant patents are awarded to people who come up with actual new species of plants or flowers. So one quick trivia question. There is only one president in the history of the United States that's ever held a patent. And if we move on to the next slide, we'll find out who that is. So Abraham Lincoln actually had a patent back in 1849. It was directed to a device for lifting boats. It was actually never implemented, but he did have a patent. So next slide, please. I want to give you an example of each of the types of patents. So for design patents, like I said, it's directed to protecting the external appearance of the object. For instance, the game consoles that are easily identifiable with the external appearance. So as soon as you see the box, it has a specific shape and design that identifies it with the Xbox. Next slide, please. Here is an example of a plant patent. This is a pretty old patent, but very popular, the famous Christmas flower or plant. And if we move on to the next slide, please. So the process of getting a patent, it's actually a very long and complex process. So I'm going to try to summarize it in a couple of minutes. So the first step in getting a patent or trying to obtain a patent should be because you have an idea, right? You thought about something that you think is new. You invented a device or a product that you think is new and that you have never seen before. Therefore, you think no one else have thought of it. So if you are thinking about getting a patent, the very first step you should take is to actually verify that you do have an invention, because chances are there are millions of people on earth. Chances are someone already thought of it. So make sure it is worth going down this path. Therefore, make sure you actually have something that is new. And how do you do that? The most basic way of doing this is doing a search. And the most basic search is Google. Do a Google search, see if someone else is selling or advertising this type of product. And beyond that, there are many other types of searches that you could do. And that's why we have, for instance, a search room in our office, because we have a specific means of searching. There are specific databases within the patent office that we can help you search for and double check and verify that your invention is not out there yet. Once you decide that, okay, you have something new and it's worth trying to get a patent, then what is this optional step that you see here? Well, you can file for a provisional application. And what is a provisional application? A provisional application is kind of a placeholder. It's like it buys you time, because it is a race to the patent office. Who makes it first to the patent office and who files for a provisional application first? Because you file for a provisional application to set your effective filing date, because the right to obtain a patent lies with the first person to file. So filing for a provisional application allows you to work on your product, see if it's marketable, even pitch presentations to investors, and you can do all of this without triggering the statutory bars, which would result in losing any prospective patent rights. A big advantage of a provisional application is that you don't have to include claims. The claims are the most complex and expensive portion of your application. Therefore, in a provisional application, you don't need to worry about that. Also, the initial cost of a provisional application is lower. But filing a provisional application, it doesn't mean that you're going to save money. It's more of a cost delaying strategy as opposed to cost reducing. But it does buy you the time. And it also gives you the opportunity to use the patent pending phrase on your product, which actually having the patent pending phrase doesn't legally prevent anyone from using or making your product, but it does act as a deterrent. So people see the patent pending and they're less likely to copy your product. And you can do all of this within 1 year. So doing this buys you 1 year of time. So after 1 year, you must file your non-provisional application. And here is where you include the claims. And filing the non-provisional application places your application on my desk. It is ready for examination. And here is where another long process starts. But in the long run, eventually, if your invention is actually new and patentable, then at the end of the road, you will get your patent and you get a nice folder with the golden seal and everything. And with that, I have concluded my part about patents, and I'm going to pass it back to Hope.
Okay. Thanks, Paola. All right, so I am going to move on to trademarks, and yes, if we can go to the next slide, thank you. What I'm going to talk about a little bit is what is a trademark and what can be trademark. So a trademark, again, as I mentioned before, is a source source identifier. It tells you who is providing that particular good or service and what kind of good or service that they are providing. There are a number of different types of trademarks. You can trademark the word itself. You can trademark a phrase. You can trademark a symbol or a logo or any combination of any of those that I just mentioned. There's another thing that is also called a service mark. And a service mark is distinguished from a trademark simply that a service mark is a trademark that is for a service rather than for an actual product. So let me show you a couple of different examples. So let's move to the next slide, please. So as I mentioned, trademarks can fall into two very typical buckets. One is the word itself. And so when you're looking at the word Starbucks, you know what Starbucks is, and you know what they actually provide. Same thing with Nike and same thing with Target. Now, what you also can do is to have a design. And so the Starbucks design or the logo is the mermaid in the green circle. And Nike, which is the swoosh symbol, which is the most recognizable trademark around the world, is the swoosh symbol. And Target is the bullseye. So if you look at the word Starbucks or the logo of the mermaid in the circle, what you know is that, hey, I want to get a cup of coffee today, and so I am going to go to a Starbucks, and I know that Starbucks provides that particular good or product, and so I will go to Starbucks. You wouldn't go to a Nike store to go and get a cup of coffee. And same thing with Nike. You would go to Nike to go and get some sports products or sports apparel because that's what they actually provide. And same thing with Target. You might buy Nike products at Target, or you might buy a cup of coffee if they have a Starbucks within a Target. And so, but what you also know is that if you want to get a computer, you wouldn't go to Starbucks to go get a computer. Instead, you would go to some place like Dell or to Target, who might provide computers, and you might be able to purchase something that is there. So again, a trademark distinguishes who is providing you the good or service and what product or service that they are actually going to be providing for you. So let's go to the next slide, please. What I'm also going to show you is a couple of what we consider non-traditional marks. And these non-traditional marks are not words or designs or logos. And so some of the trademarks can be what we consider color. So the Tiffany blue is a trademark, and that particular blue color on a box, as shown there, is very distinguishable. You know that it's Tiffany's that is going to be providing that particular jewelry that you're going to be getting. Same thing with UPS. The UPS brown and associated with mail delivery or package delivery services, that is trademarked by UPS, as well as the John Deere green on equipment, right? And so all of those particular colors are also something that is a source identifier, and so that is why it is considered a trademark. Next slide, please. Something that you don't typically think of is smells. Right? So there are certain smells that are out there that tell you who is providing specific products. And so this Groovy Grape liquid power car wash, I think it's a car wash, they actually have a certain smell. And so they have actually applied for a trademark. Verizon, in case you didn't know, Verizon stores have a very distinguished smell. So when you walk into a Verizon store, you know that that is a Verizon store. And Play-Doh, believe it or not, the Play-Doh scent, that dough scent that you remember from when you were a child, that is a scent that is trademarked as well. Next slide, please. Something else that is actually trademarked is a sound. And so when you hear different things, that is something that is a source identifier. The Pillsbury Doughboy, their laugh, that is a sound that when you hear it, you know it is Pillsbury and what product you're going to get. Same thing with NBC, NBC, or you hear the chimes for that, right? So when you hear that those three notes in that order, you know that you are watching NBC. Same thing with Mario Brothers, right? That's the coin that's at the very end, and that has a very distinct sound when you are playing a game, the Mario Brothers game at the end of the day. Last slide, please, on trademarks. So the other thing is trade dress. So trade dress is a combination of different things on the look and feel that is also a source identifier. And so the particular shoe or the Hershey Kiss, the wrapping on that, or the Apple Store, the shape of the Coca-Cola bottle, all of those are also source identifiers of different products. So all of these are different things that can be considered with respect to trademarks and our source identifiers. There was a question early on that was brought up with respect to 1-800-Flowers or 1-800-Accountants. And so the question really was, is that intellectual property? And I said maybe. And the reason that I said maybe is that the question really is, at the end of the day, is it a source identifier, right? Is 1-800 a source identifier of a particular flower company, okay? And so that's really the question at the end of the day. You can't get a trademark for something that is what's considered generic. And because what trademark does is it takes the vocabulary out of usage in business, and you can't use that as if you have a trademark or you own the trademark at the end of the day. So the question for a company like 1-800-Flowers or 1-800-Accountants is it an identifier for that specific company? And if it is, and we were to ask the question on whether to get out of commerce, will someone else now just not be able to use it? Is it generic, and should we be taking it out of commerce? So maybe, I don't know exactly. I don't know if they filed for a trademark. I would have to look that up. But that's one of the standards that you would have to look at to try to figure out if you can get a trademark for that. Okay. I'm going to move on to the next two types of intellectual property. I'm actually going to speed it up a little bit more so that we can get to resources and then additional questions at the end of the day. So copyrights. So if we can flip to the next slide. So what is a copyright? A copyright is an original work of authorship. So you created it yourself. Well, and it is artistic, and it is embodied in a medium, and so in a tangible medium. And so what does that really mean? If we can go to the next slide. Okay. So examples of that are songs, right? Songs is music that is actually the musical score itself. If it's printed on a piece of paper, that has a copyright. It is the actual score when someone actually plays it and records it on, in this case, on an MP3 player or on a DVD or a CD. Once it is recorded onto that, a copyright exists. For a book, same thing. Someone asked about children's books on Amazon. Once it's actually physically printed onto that actual piece of paper, or it's saved onto a computer or the memory device for that particular book, yes, the copyright exists for that. Same thing on movies, right, and sculptures. Once all of that is saved onto some sort of tangible medium, your copyright automatically exists. You don't need to actually record it in the Copyright Office for your copyright to exist. there are benefits, and we can talk about that a little bit later, on why you want to record a copyright or register it with the Copyright Office. You get some protections from customs that you can leverage. And so, but just know that just by the pure fact that you have a creative work that is embodied in a tangible medium, you have a copyright automatically. Okay, so let's flip through 2 slides. If we can move forward, trade secrets. Okay, trade secrets. The last thing that I'm going to cover is trade secrets. And a trade secret is anything that is kept secret that there is value associated with it, and monetary value that is associated with it. And so the key is that it has to be kept secret, because once it gets out, then it is no longer a secret, and there is, and it can no longer be considered a trade secret. And when you have a secret, you have to do affirmative actions to keep it a secret. And so in order, you can't just say, hey, I have a secret, I wrote it down, and I left it open on my desk. I have this magic formula. You have to actually do things to keep it locked away and out of sight so that it is maintained a secret. Okay? And so let's go to the next slide, please. So when you think of trade secrets, it's actually the polar opposite of patents. And so patents is something that you share with the public to be able to advance technology and move technology forward. Trade secrets, on the other hand, is something that you keep secret and you don't want to share with others. And so there are pros and cons in doing either one of those. And so some of them are listed here, but in an interest of time, I'm going to go ahead and move forward and beyond this, but I'm happy to talk to you about this in a one-on-one session or other questions in the future. And so let's go to the next slide. So some famous trade secrets. Coca-Cola is the most famous trade secret that is out there, that the recipe for the Coca-Cola formula mentioned the Kentucky Fried Chicken recipe, as well as Krispy Kreme. But trade secrets are not necessarily only recipes. The Google search engine executable code, that is also a trade secret. And so that's something that Google has not let other people know about. And so anyways, just wanted to let you know that that is also maintained as a trade secret. Customer lists can also, especially in Texas, be considered a trade secret. And so that is something to keep in mind as well. It's anything that there's a value to keep secret. That particular information is considered a trade secret. All right. So next slide is just a quick overview of all the 4 buckets. I know that this slide deck is going to be made available to you, but this kind of summarizes everything. So Paola, I'm going to turn it over to you real quick to go over some resources, and then we can open it up to other questions as well.
Thank you, Hope. So if we could advance to the first page of resources, we have a ton of resources, so I'm not gonna sit here and read every single page. The main takeaway from this is when you go to the homepage of the uspto.gov, go to the search box and type Texas, and that will take you to our regional office, and you can take it from there. I mean, the easiest way is to find a contact, find our phone number or email. I actually gave you already my email, and shoot us your questions in there. Now, if we advance to the next slide, we have startup resources, which can also be found on the website. And if we move on, please, there is a Trademark Assistance Center for your trademark related questions or questions. And if we move on to the next slide, we also have the Inventors Assistance Center. This is more to patent-related questions. We move on, please, there is the myuspto.gov. This is after you have filed for a patent or a trademark. This is kind of where you manage your portfolio. If we move on, we have an app also for tracking the status of your trademark application. And moving on, we also have a tool that is called the IP Awareness Assessment Tool. Let's move on. And please, I know I'm like flying through this, but you are going to get a copy of all of these resources, and you can select which one is the one that in particular can help you. We have a pro bono program. And so just make sure that you read the criteria and that you qualify for this. There are specific pro bono program organizations in each specific state. If you move on, the one to the next slide and then the next one, the pro bono program in Texas is called TALA, and it's located in Austin. And there is the contact information for TALA if you qualify for the pro bono. If not, another option that you have is, we move to the next slide, is the law school clinics. Similarly, the PTO has a law school clinic program in which law school students get involved, and they work under the supervision of trained patent attorneys, and that's also something you can use in your benefit. If we move on, there are the specific locations for the law school clinics throughout the country, and in the next slide is a specific contact for the law school in Texas. Moving on, there's also something called the PTRC, which are nationwide public libraries that work hand in hand with the PTO, and they're also trained and adequate to give you guidance regarding IP. We work very close with them, so that's another thing that we highly encourage that you do. Moving on, if you have applied for a patent, there is a program called Track One to expedite the issue of your patent. Moving on, once you already are in the process of getting a patent, your attorney or you can request to talk to us, the examiners. That's something else that is highly encouraged because it really expedites and helps in the process of obtaining your patent. And in the next slide, we have the information on our patents ombudsman. And lastly, in the last slide, you can qualify for a microentity status. If you do qualify, you get discounts on all of the fees, specific discounts. Again, you gotta make sure that you meet the criteria to be a microentity. And that's it. We have one more slide, and that concludes our presentation. And I believe we are going to open it up now for questions. The USPTO website is www.uspto.gov.
Great, thank you. That was such great information and so much. There was a lot I learned as well, so we really appreciate that. So let me see, you had answered the first question about the 1-800 numbers, but then she asked, we have used 877 Passport for over a decade. What do you recommend?
Okay, so here's a question that is going to be answered at the end of the day. And when you send in a application to our office, the question that is always asked is there a likelihood of confusion on whether someone else is going to be providing that service, right? And so that is what the basis of your trademark is, right? It is to a single source and not to multiple sources. And if it's going to cause a likelihood of confusion with someone else, then that is something that you won't be able to register. Now, on the other hand, let's say in this particular case, I mean, you've been using this particular telephone number for a decade, as you mentioned. Now, there are other rights that you accrue even though you haven't actually registered your trademark. So trademark rights accrue from usage of that mark in connection with your good or service. And so you can do a number of different things. You can officially register with my office, and then you can get nationwide protection because you've registered. You can register with each of the individual states themselves. If you are only planning on doing business within one state, within Texas, you can go ahead, for example, you can just apply with the Secretary of State, and they can grant you a trademark for Texas only, so it'll only protect you here. Or the third way is if you don't register at all, you develop what is called common law rights. But common law rights are based on geographic basis. And so if you have been using 1877 passport only within Dallas, for example, or in the Denton area, and someone else has been using it in Houston for the same amount of time, then you may be only limited to Dallas or to the Denton area. Now, how big your geographic scope is, it's hard to say. It's going to be a question of law at the end of the day, because let's say that person only used it in Arkansas or in Michigan, for example. So do you get the entire southern sector? I don't know. It really depends on what you've been doing business. And so by getting those common law rights, you already have it at the end of the day, but bigger protection can be found if you actually register with the USPTO, for example.
Great, thank you. Okay, what protections do consumers have on products with patent pending?
So there's a couple of different things that are associated with patents pending. One is that when you have patents pending, you've put people on notice that you have an idea that may be patentable and is in the patent process. And so you're not going to be able to enforce your patent until you actually get the patent granted. But what it does is it puts the ticker on the clock. Okay, and so let's say you file a provisional patent and you file it today, but tomorrow someone starts selling your exact same idea that you have put into a patent. Now, after you've gone through the entire patent process and you can and you have already gotten your patent, and it'll probably be about 2 or 3 years down the road. But once you get it, you can go back to the date when they first began selling the product, and you can sue them for it and get what's called back damages. Okay, and so you may be able to ask them for a license at that point in time. So that's what the benefit is from a legal standpoint and recovery of costs on filing it and to have that patent pending. It also is nice because it gives angel investors, venture capitalists, or other people who might be interested in your company, it gives them an incentive to fund you and your business because they say, hey, she could have something really valuable in this company. And even if the company itself doesn't work out, you have an asset that you are going to be able to sell possibly at the end of the day. So it provides a little bit more security interest at the end of the day.
Great, thank you. Does a NFT, fungible token, need a patent pending?
Okay, I am not familiar with what a non-fungible token is. Paola, do you know what that is?
I know what that is, but I do not know if they need a patent pending. I think in general, I mean, no product really needs a patent pending, but it is very helpful, like Hope just explained. And because of the nature of an NFT, I don't know if those are actually patentable or those are copyrightable. So I'm sorry, we can definitely find out more and get back to you with an answer, with a more educated answer.
Great, thank you. Yeah, I don't even know if I pronounced that one right either. I had to look it up. It's called a blockchain, or it's a unit of data stored on a digital ledger. So, okay, do you guys know of any of the law schools that are actually running their clinics during the summer to help with trademark? They've checked with A&M and Baylor.
As far as I know, those law schools do run year-round, and so their clinics are usually year-round. So I would definitely reach out to them at the contacts. Their contacts are found on our USPTO website. You can also find them after this meeting when we send out, or when Tracy and Donalisa send out the presentation to y'all. But a lot of the the law clinics do run throughout the entire year.
Okay, I knew the A&M one didn't during the summer, but great, thank you for that. Can you file a trademark on your own?
You could. And so the process itself is fairly simple. And so when we have a number of different videos that are on site that will walk you through the process of going through each and every one of the steps. But I want to make sure that you choose everything correctly. So make sure that you choose the appropriate goods or services, and that you're filing the drawings correctly. So make sure you're following each of the steps, because what happens is that once you file that trademark application, you are locked in to that trademark. Okay, you can't change the goods or services, and you can't change the logo. So some of the biggest mistakes that we see, for example, is that if you have a logo and that you are sending that in, if you don't have a clear copy of that logo, and when you send it in and there's all these granulated lines or something in it, what we get is the mark that you get. And so you don't get protection on the actual solid mark, you get the protection on what that actually looks like. So make sure that when you are doing all this, that you are very careful, that all the details are put in there so that you can get the maximum results. Now, we do recommend that if you can, use the resources that we've provided on that, because what happens is that after you send in your application, one of the things that happens is that you're going to get what's called an office action, and you're going to have to respond to that office action, and sometimes it gets a little bit confusing because you don't know what it is, and so then you're going to need to probably talk to an attorney to be able to help you respond to those particular office actions.
Okay, great. For software applications, would I need a trademark, copyright, and design patent?
Okay, so for a software application, that actually would fall under a copyright and a regular patent, not a design patent. So design patent is look and feel, okay, so it's ornamental. And so a utility patent is something that you would consider. And so a software application, what that would fall under is a process. And so if you were to take the step-by-step processes of your actual software application, that is what would actually be in your patent application. The executable code itself, that it can also be copyrighted, right? So it'll be protected by copyright, and you can register that with the Copyright Office. So those are the two buckets that you would be looking at for software.
Okay, great. We've got all kinds of questions. So I guess the question is, who is liable if you have a patent pending, but someone reverse engineers it without your safety features and the consumer is harmed?
Okay, so if you have a patent pending, the patent pending, you can't sue on that patent. Okay, so you have to wait until it is actually a full-blown patent before you can actually sue on that. And with respect to the actual liability, I think it's going to depend, because a patent only grants you the right to allow others to make, use, and manufacture, import, and your particular idea. It doesn't grant them they can go off and make it and do whatever they want with it. They can manufacture it, right? And it is your responsibility to enforce them the right to not infringe your patent. And so if someone else is making it and they've actually made it, then this is my non-legal opinion because I can't give legal advice. It is their responsibility, right? They're the ones that actually made it. They didn't get your permission to make it, and so now they've infringed your actual patent. And so you can sue them for that, and the FTC and the other OSHA and whoever can sue them for product liability and safety issues. And so it is their responsibility. They actually made it.
Okay, great. There's so many different things that can happen here with patents and trademarks. If you submit a trademark for a phrase for merchandise, do you have any protection if you choose to move forward with printing your own merchandise?
If you submit a trademark for a phrase, do you have any protection? Okay. So if you submit a trademark for a phrase into my office, I'm assuming that's what, for merchandise, and before it is actually registered, then you do have what's called common law protection. So once you start printing it and selling it, that means you're using it in commerce, right? Then you do have common law rights until the actual trademark is registered with our office. Now, the trademark registration is effective as of the date that you register with our office. And so if you register today and you start making and selling it tomorrow, then once you get that registration, you have protection on that. But if you started printing yesterday and you register today, then your protection yesterday is common law rights, but your protection today forward is going to be your trademark rights.
Okay, great. What does an app and book need for protection?
Okay, so for the app, I think I mentioned this earlier. The app, you can get it protected by copyright as well as by patent. For the book, you would use copyright to protect that particular aspect.
Great. Does a patent in the USA apply worldwide? If not, how do you make sure it is valid worldwide?
Paola, do you want to answer that question? I could answer it, but I figured you can too.
You gave me the hard one. Okay. This is so hard because, okay, a patent, if you apply for a patent in the USA, you get a patent for only in the USA. If you want to enforce it outside of the USA, you would need to file for an international application. And that's my short answer, and I'm going to let Hope elaborate on that one.
Okay, yeah, let me elaborate on that. Your rights to a particular patent is going to be country specific. Okay, so if you want to protect and enforce your patent in Europe, then you need to file an EU patent. Now, understand your EU patent is only going to be effective to those countries that are participating in the EU. So with Brexit now, your patent is not going to be covering Great Britain. So each and every country that you want to file a patent for, you need to file it in that particular jurisdiction, and it is only valid in that particular jurisdiction. Now, the international patents that Paola had mentioned is that we do have treaties with countries around the world. And so what you can do is you can use that treaty to allow you to file a certain application in that particular country. So, for example, if you file an application, it's called a PCT application in your home country. If that home country is the United States, then you can also check to say that, hey, you want this application to also go to the EU, to China, to Japan, to Australia, okay? And then that particular application will be sent individually to each one of those countries. But each one of those countries are going to evaluate their patent based on their patent rules. And so they will grant you a patent based on their rules. And if you get a patent in that country, it is effective in that country and that country alone, and not in multiple countries.
Okay, that was great. Thank you guys so much. We appreciate you guys coming out tonight. This is such great information. And as we've said, the replay link and slide presentation will be mailed out to everyone that registered tomorrow. I think this is something everyone really enjoyed. Thank you, ladies, so much.
Thank you.
You bet. And we've got your information now that we can pass on as well for those that are interested in one-on-ones. And I could see through all of this how beneficial that would be. So thank you everyone for attending. We're so glad everyone was here tonight. The next thing we have coming up will be our Women Rise, right, Donna Lisa, in July?
Yes, our Women Rise, July 13th.
Yeah, 9 proven strategies to profitably and powerfully scale your business. We appreciate everybody being here, and we hope to see you at another event. And ladies, thank you again so much. That was great information.
Thank you. Thank you so much.